Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. All right, we are back in Murray, Kentucky with attorney Jeff Roberts, and today we are going to talk about the issue that comes up fairly often when you're in a car wreck or a motorcycle accident, or even if you've had a workers' comp claim, and that's when you're asked by the insurance company to give a recorded statement. Jeff, welcome back, guy.
Good morning.
So here we are talking about recorded statements, and that always kind of throws up red flags because once it's recorded, it never goes away. It's kind of like my kindergarten permanent record thing. It just gets bigger and bigger.
Yeah, exactly, and I'm kind of glad I grew up at a time before cell phones and videos and internet was around. So
absolutely. Well, so let's talk about this. First of all, let's address it from the personal injury side. So primarily motor vehicle accident side, and then we'll cover workers' comp. It's a little bit different, obviously.
Yes.
Now, usually this is the insurance company that's asking you. They may give you a quick phone call and say, hey, we'd like to take a recorded statement. That ought to throw up some red flags, I would think.
Yeah. Normally, when a recorded statement is requested, it's requested by the at-fault drivers or the opposing insurance company. Is the one that is asking for the recorded statement. And when they're asking for a recorded statement, they're going to be asking some different things of you during that recorded statement. They're going to talk about, if you give the recorded statement anyway, they're going to ask you about what happened, what injuries you've received, what medical treatment you've received, and they're going to talk to you about any past medical histories that you have. But what they're going to do is try to phrase the questions in a way that favors them. They're going to try to make it, ask questions in such a way to make it look like you're at least partially at fault in causing the accident, or that you had other problems with this condition, or to limit what you're complaining of as far as your pain, so that if something develops later on, they can say, well, you didn't, we talked to you a week after or 2 weeks after this injury, and you told us you had pain in your leg. You didn't mention anything about low back pain. And so they're trying to get the recorded statement to be able to use later on to affect how much they have to pay you later on in regard to, reducing damages because you had pre-existing issues, because this problem is not work-related, or you're partially at fault in causing the accident. So my advice normally with someone who does not have an attorney involved is, first off, when they ask for a recorded statement, that's probably the time to make a contact with an attorney to see if you need to have an attorney involved in this case. If you haven't already made contact, then reach out to an attorney and talk with them at that point in time. And generally, I don't like recorded statements in these cases. If you don't have an attorney, I would not give a recorded statement to the insurance company. There's no requirement that you give the other the other driver's insurance company a recorded statement there. And they're not needed in these cases. And I know they're not needed because most of the time when they ask me after I get involved in the case and they tell me they want to have a recorded statement of my client, my response is never a no, we're not going to do that. My response is, fine, I'm fine with you taking a recorded statement of my client if I can take a recorded statement of your insured at the same time. So tell me when your insured's available and you're available, and we'll schedule this. And in 31 years of practicing personal injury law, I've never had the insurance company follow back up and say, okay, we'll set it up to where you can take our insured statements while we take your client's statement at the same time, or one right after the other. They never mention it again.
Isn't that funny? Isn't that funny?
Exactly. They never mention a recorded statement again, which tells me they don't need the recorded statement. The recorded statement, there's a significant reason why they wanted the recorded statement. The same reason I want to take their insured statement. From that standpoint, they never let me take their insured statement, and they don't take my client's statement if I don't get to take their insurance statement.
In 2 quick points, the insurance adjuster on the other side does this 5-6 days a week. He or she knows what they're doing. They're training. They negotiate. They know how to angle these questions and do all this other stuff. This may be your first car wreck, or maybe you've been in a couple, but nothing major. You're not really aware of what's going on, and so it's easy to kind of give an answer that's taken out of context later. And now you, as their attorney, has to try to deal with that. But at the same time, I want to differentiate this. This is not a deposition, right? This is a different.
Correct.
The different animal altogether.
Yeah, this would be done over the phone 99% of the time. This is going to be done over the phone. There are some companies, really about only one, that has local adjusters now, where the adjuster would come meet you somewhere. But the vast majority of these are over the phone recorded statements that are taken in that situation, and that's. And you're absolutely right. The adjusters do this day in, day out. They're trained on how to do these, and they're working off a list of questions that has been drafted most likely by someone who's done a lot of insurance defense work and defended a lot of car wreck cases, and they're working off questions that they have drafted up for them.
Those are the attorneys who work for the insurance
Yeah,
company.
exactly. And so they're using that form to ask these questions, but they're also trained. And you can, regardless of the answer, you can make something look the way you want to. If you're involved in a wreck and I ask you, when did you first see my client in his vehicle? When did you first see him before the wreck? Well, if you say, I saw the vehicle, 20 seconds before the wreck. Then later on at some point in time, somebody's going to say, well, you had plenty of time to avoid this wreck. You saw him 20 seconds beforehand. And then if you say, I just saw him a split second before the wreck, take that. You weren't paying attention. Otherwise, you would have seen him much sooner than what you saw him. So however you answer it, they can try to spin that to be used against you later on. Whereas if you have if you do give a recorded statement and your attorney's present, your attorney hopefully smart enough to know to go back and ask some of these things, and why did you not see him a split second but a split second beforehand? And that's because he come from a side street and there was my view was blocked and he run a red light or a stop sign in front of me or whatever it may be, and you can it can be, the damage can be limited or eliminated if you do it, but it's better to have someone there who knows what they're doing. But most of the time, your attorney's going to avoid giving that recorded statement completely.
Well, we've talked about this in a previous episode that Kentucky is a pure comparative fault. So depending on how you answer that, they can say, well, you're partially at fault for this, so we don't have to pay the full bill.
Correct.
For the damages of the negligent
the full
driver.
damages, yes. If you're 1% at fault in Kentucky, then your damages are reduced by 1%. And frankly, I think that's the way it ought to be. I like pure comparative fault. I think that's the way it is. If some states it's different. If you're 50% at fault, you may not get anything back from that standpoint. So, to me, I like that. But in the personal injury, the car wreck context, there is another insurance involved too, not just the at-fault party's insurance, but your insurance is involved. We've talked multiple times about PIP or basic reparations or no-fault benefits, and sometimes it's rare, but sometimes your insurance, your PIP insurance, the PIP carrier, which is your insurance, may ask for a recorded statement, and then your insurance contract, in all likelihood, has a provision in it that you have to cooperate with your insurance company or they can deny the claim. So in that situation, then you may be required to give the recorded statement to your own insurance company in that setting. If it's other driver's insurance company, there's nothing that requires it. But if it's your insurance company, you may be required to give that recorded statement.
Because you have a contract with your insurance company.
Exactly. You have a contract with the insurance company that says you will cooperate with them. Again, that's another setting. If your insurance company is asking for that recorded statement, if you've not already reached out to an attorney, that's the time to make the call and talk to an attorney and let them advise you on what you need to do. If you need an attorney involved in that claim, if you need an attorney involved in that recorded statement, and deal with it from that standpoint, because the insurance company's having somebody advise them or trained making those decisions. You need somebody that's trained helping you through the process as well.
Well, it's kind of like we used to say it out on the playground after lunch, no takebacks. So if you say it and it's recorded, I mean, it's kind of there.
It is.
Now you got to deal with it.
Yes.
You know, that's one of the issues. Not that you shouldn't be truthful, I mean, but you can make a statement and not really understand, you know, wow, I didn't realize I was admitting to something that really wasn't actually accurate.
Yeah, and you may not completely understand the question. Exactly. And, you know, and even if, though you're giving the statement to your insurance company, there's potential that the other side is going to get that at some point in time.
Right.
They will if a case gets in litigation, I guarantee you will be asked at some point in time, have you given a recorded statement to anyone, and if so, who has possession of that recorded statement? And you got to say, if you've given it to your insurance company, you got to be honest and say, yes, this is who I gave it to, and then they're going to go up to them and try to get that recorded statement from them. So it's going to come back. You're going to see it again at some point in time if you ever give one.
Are there some general questions they're going to ask? I mean, typically, are there a list of questions that you encounter when somebody's trying to get a recorded statement from your client?
They have a list of questions they're going to ask the client, yes. And like I think I mentioned it earlier, but what they're going to be asking as far as topics is what happened as far as the wreck itself, what occurred. They're going to ask what problems you have as a result of that wreck, what medical treatment you've had since the wreck, and then they're going to ask you about general medical issues prior to the wreck. You know, if you've got, you know, if you're suffering neck problems beforehand, they're going to know, have you ever seen a doctor for neck issues, ever complained of neck problems before? If it's low back, have you ever complained of low back issues before? And that's where those come in. And you know, you may not remember 10 years ago that you saw your family doctor and you'd been chopping wood or cutting a tree down and had a little low back pain and didn't have anything else done after that. But if it's in that medical record, it can come back later on. Then if you say, no, I've never had low back pain, and they find it, that's part of the reason why you don't want to give those recorded statements if you can avoid it.
Exactly, and that could be a simple mistake, but I mean they're going to do everything they can to kind of use it against you. Jeff, let's do this. Let's go ahead and transition now. We've talked about when you're in an automobile accident, when you're in that kind of a situation, that kind of a personal injury situation, but there's also the possibility you may have been injured at work. So now we're talking in the workers' comp environment. Now we're dealing with a different type of claim altogether. Still an injury, but it's different. And you said these recorded statements are actually treated a little differently, correct?
They are treated differently in a workers' comp claim than they are in a personal injury claim. You know, in the personal injury claim, the car wreck case, the at-fault party's insurance is not going to pay a dime until the case is resolved completely. They're not giving you any money. They'll pay property damage maybe, but they're not going to pay any medical bills. They're not going to pay any lost wages. That's what PIP is for, and your health insurance and short-term disability, you have it. When they pay, it's when the case is resolved. In workers' comp, that's different. In workers' comp, they're going to pay the medical as it's incurred. They're going to pay the lost wages as it's incurred. So you have an incentive or a reason to be more cooperative with them, because there's consequences if you're not. If you don't give a recorded statement to the at-fault party in a car wreck, that doesn't affect you later on when you resolve the claim. But in workers' comp, if they ask for a recorded statement, and they're entitled to know if you've got a low back injury, they're entitled to know if you've treated for low back problems a year prior to that. And if you don't give that recorded statement to them, then they may take that as saying, okay, we're denying this claim because we can't fully investigate whether you had this problem before and it's not really a work-related injury or if it is a work-related injury. So in a workers' comp claim, I do have my clients, if they ask for a recorded statement, I do let them take a recorded statement of my client in that setting. There are times that I say, sure, but I want to do a recorded statement of the coworker. Usually don't in that because I can go to the coworker if there's not an attorney involved and get that recorded statement anyway. So I let them take the recorded statement of my client with me being present and me listening in on the call so that I can address anything that my client may say, clarify or ask clarifying questions and things. But also in a big part of it, I can prepare my client ahead of time for that recorded statement.
In a spot a question that's just out of bounds.
Yeah.
That's that games are played.
Correct.
Games are played. Jeff, earlier in this episode, we said, when you hear the insurance company saying, hey, we'd like to do a recorded statement, that should throw up a red flag and you probably ought to call an attorney. I would have assumed that is the same thing in a workers' comp claim, right?
It is. That is a time that you need to think about getting legal advice as well. So that is a good time to make a phone call to an attorney and tell the person, when they're doing it, so, well, before I give a recorded statement, I want to talk to an attorney, and they shouldn't have any problem with that. If they have a problem with it, then you got to wonder what they're going to plan on asking you in the recorded statement from that standpoint. And if they say, well, okay, we won't take a recorded statement, then don't worry about it. They were planning on asking you, and then you definitely need to talk to an attorney. But that's a situation where still, you go talk to an attorney, and it may be, they come in to see me, and I say, here's what, this is what's going to take place. Here's the way to address it. And if they don't need me at that point, I'll say, I don't know that you need me yet. But that is a time to reach out to an attorney and get and find out what your rights are and what's going on.
Well, let me ask you this. I mean, a lot of people, if they're off work, maybe they're hurt just driving around. Maybe they got T-bone in an intersection and they just can't get to work, so money's starting to get tight. Maybe it's a work-related injury, so they're off work again. They're getting some things come through. They say, okay, I need a consultant with an attorney, but I don't have the money to pay for an attorney. How does that work?
Well, with me, the way it works is because I work on a contingency fee basis. So if you come in, schedule an appointment with me, you don't pay anything when you come in for that appointment. I get paid when the case is over with, when I'm successful. When I give money to my client is when I get money. In these cases, it's a contingent fee, which means it's contingent upon recovery. If there's no recovery, there's no fee. If there's a recovery, then I get a fee. And I do the same with the expenses as well. Some attorneys have clients advance the costs, the expenses that they're going to incur, costs for medical records, deposition costs, things of that nature. I don't do that. I advance that cost, and that's also contingent. So if I'm successful, I'll get paid my attorney fee and reimburse my expenses. If I'm not successful, the client doesn't owe me an attorney fee. They don't owe me reimbursement of my expenses. So I understand that concern. I've had clients bring that up when they come in to see me, or when they call and say, how much is this going to cost? The first appointment doesn't cost you anything. Second appointment, if I take the case, second, third, fourth appointment doesn't cost you anything. It's when the case is resolved and I get a percentage of what I've recovered for you.
And that's all spelled out in your contract anyway. So it's a way to let the average person get good qualified legal help, especially when they're up against the insurance companies like that and all their attorneys as well.
Exactly. Most of the clients I represent could not afford the attorney fees. They live paycheck to paycheck or very close to that. And, they can't write a check for a retainer fee in an hourly rate from that standpoint. So the contingency fee arrangement that we have in Kentucky and every other state that I'm aware of, it basically is the way the courthouse doors are kept open for, frankly, the poor and the middle class. And so the courthouse just isn't available to the rich. And that's the reason the contingent fee is around, and that's the reason it's very important to keep around.
Perfect. Jeff, let's come back to, again, recorded statements when it's involved in a workers' comp claim. Now, are they going to focus on medical, or kind of what are they fishing around for there?
Very similar to what they're going to be asking in the personal injury context. They're going to ask about the work injury, what happened that caused the injury. They're going to ask you, were you hurting? What injuries did you receive? They're going to ask again about the medical treatment that you've received since the work injury, and then they're going to ask about prior medical issues that may be having a bearing on this. So if you lifted a heavy box and had low back pain, they're going to ask, have you ever had low back pain before? Or have you been diagnosed with any type of arthritis in your spine or anything like that? So they will ask those questions, and who you've treated with for the past several years. Usually they'll go back 5 years or more on asking you from that standpoint. They'll ask about treatment all as far back as you can recall. And if you say, yeah, I've had low back issues, but it's been 20 years ago, they're going to ask who you saw 20 years ago for those low back issues. But even if you haven't, they're going to want to know who your family doctor is, what other doctors you've seen over the past 5 years, so they can get those records to see if you've had any similar complaints, or if there's a doctor there you didn't mention that they need to get records that may have had similar complaints.
And again, the idea here is very similar to a car wreck situation. They're trying to shift some of that expense or some of that responsibility and be able to blame it on a pre-existing condition.
Correct. That's part of, they're trying to blame it on a pre-existing condition. Yes, that's in part, the problem wouldn't be as bad if it wasn't for this pre-existing condition, so we shouldn't have to pay for the pre-existing condition part of it. That was an active problem. And the other side of it is, they tried to say, well, and they'll ask about your activities. And somebody who has shoulder problems, if they find out you play golf, they're going to ask you, do you play golf? How often do you play golf? How frequently do you play? Did you play the week leading up to this injury? Have you played any since this injury? And so they're going to try to find something else that they can blame for your problems as well. That's one of the things that they're trying to do.
That makes sense. Unlike a personal injury case, unlike an accident, these are not, workers' comp is an administrative law, system. So it's not like what you see on TV with CIS. There's not going to be a jury around. I mean, none of this is going to actually play out in that type of a courtroom. This is going to be between the insurance company, your attorney, you, and the judge, ideally. It's just a different environment. A lot of people aren't really ready for that, right?
Correct. A workers' compensation claim is an administrative claim, so it goes in front of an administrative law judge. The judge acts as judge and jury in these cases. He makes the legal rulings, but he also makes the factual decisions and decides, what witnesses to believe and what witnesses to disbelieve. And that's part of the reason why you need to be careful in these recorded statements in how you word things in what you say, because that can come back to it can come back and be played in front of the judge at the final hearing, and the judge can hear what you said. And if you tell the adjuster, I've never had low back problems before, and then they get records showing you had low back problems for the 5 years up until a year before the injury, that you've got you've got some explaining to do then, Lucy. And so those things are, and it may be that we can deal with it. If the low back issues before were at a different level in your spine and the pain was going to a different location, it may be a completely different injury. And if we know that, we can deal with it and we can address it and do that in the recorded statement. But if you deny it completely, doesn't matter that it's at a different level and the record shows it's a different level. The judge starts downplaying everything and second guessing everything you say at that point.
Yeah, once you get behind that 8 ball, it's awful hard to get back out in front of it, right?
Extremely hard to get back out in front of it.
I would think so. Yeah. Jeff, now, obviously there are some benefits to actually giving a recorded statement. I mean, you kind of get some facts out and you can kind of go on offense a little bit there. You want to kind of describe how that works?
Well, yeah, and it can be beneficial to do the recorded statement in some regards. And from a workers' comp claim, if you don't do the recorded statement, they're not going to pay your medical treatment. They're going to deny the claim, and you're not going to get paid the medical and the lost wages when you're off work getting the medical treatment. So there are consequences in a workers' comp claim to not doing a recorded statement from that standpoint. But it can also be beneficial if you've got a safety violation issue, for instance, and say, yeah, they took, I was working on this machine, and I told them that this safety stop was not working, and I've been telling them for a month, 2 months that this safety stop is not working, and they just kept ignoring it and telling me to continue to run the machine even though the safety was malfunctioned on it, and now I'm injured because of it. Well, that can come back and be very, very helpful to us later on. And in a recorded statement, if you give a recorded statement, I can eventually get that recorded statement. So if you told the workers' comp adjuster that a week after the injury, and later on they tried to say, well, after his attorney got involved, he's trying to argue that a safety violation. From there, and I can go back and say, recorded statement a week after he told the adjuster he'd complained for 3 months about this safety being broken. They didn't do anything about it until a week after his injury, and they fixed it after the injury. They didn't fix it before.
Miraculously.
Yeah, and so it can actually be somewhat beneficial involved in. In fact, I've made sure I've had clients do recorded statements where after the insurance company adjuster stopped asking questions, and I come back in and said, you talked about this thing. Did this machine have a guard? Well, it didn't when I got injured, but it had a guard before, and they took the guard off because they thought it was slowing us down, so they took the guard off the machine. And I talked to them a lot about that in that recorded statement in that setting, and that can end up increasing the value of the claim later on, even without having to go into litigation, because the adjuster looks at it and says, okay, we could be facing the safety penalty here, and that gets taken into account earlier instead of later.
Which gives you a little bit more leverage in the negotiations altogether. And this whole thing's a negotiation.
Yes.
Yeah, really. Jeff, generally speaking, can you give us more of an idea of what they're going to ask in a workers' comp scenario where they're asking for a recorded statement? I guess it's going to be kind of the general facts, what was going on.
Yeah.
What?
Yeah, and yeah, like I said earlier, they're going to talk about the injury, what occurred, who was present, who witnessed it, what injuries you've received, what medical treatment you've received from that, prior medical issues, things like that. That's essentially what they're going to be covering. Very similar to what they ask in a personal injury one. Frankly, very similar to what I ask my clients in the initial meeting. Recorded statements are very similar to the same questions I ask my clients. And mine aren't slanted when I ask them in my initial meetings with the client from that standpoint, but very, very similar type of information, just gathering what happened, what injuries are the result of this, and going through it the same way.
Well, Jeff, let me ask you this. I know in your general practice, you handle all sorts of motor vehicle accidents. So this could be trucking collisions, this could be motorcycle wrecks, it could be automobile accidents. You cover those. You also handle the workers' comp claims, as we've talked about, and Social Security disability, which we've talked about in numerous episodes here. You actually now have two offices. Your primary office is here in Louisville. I'm sorry, down here in Murray. I just drove in from Louisville. But you've also got the new office up there in Hopkinsville.
Yes. I got the office in Hopkinsville on Virginia Place in Hopkinsville, and I opened that up earlier this year. As you know, I've got several clients, and for several years I've had a lot of clients in Trigg County and Christian County, and even further north than that. And so it just makes it easier to meet with those clients. They don't have to drive as far. I set it up where I have 3 or 4 or 5 appointments in one day there at Hopkinsville, meet with them at the Hopkinsville office. And it's worked out better for my clients up in that area, saves them some drive time, and frankly, I kind of like getting out and driving through Land Between Lakes is always beautiful. Driving across the lakes and looking at that it's enjoyable and gets me a chance to think about some things without the phone ringing and staff coming in as well. So I get some mental work done on the way up as well. So
That makes sense. Now, Jeff, you've mentioned that you've handled some cases even further north than that whole Christian County region. In all reality, you get called from across the state because with your license, I mean, you can handle a car wreck case, a motorcycle accident case, a workers' comp case all across the Commonwealth, right?
yes, and I do. I frequently get calls from past clients that have moved out of the area or have family members that live out of the area who've had a work injury or a motorcycle wreck or a car wreck, and then attorneys that may not do the same area of law I do, but know me and know my reputation, and they call me up and ask me to help out on cases from that standpoint. So yeah, that does the same, and regardless of whether you're here in Murray, Christian County, or whether you're further away, you can reach out to me. Best way to reach out to me is by phone. If you call during business hours, you're most likely going to have a live human being answer the phone, unless we're on all the other lines. At that point in time, you're going to have that time you may get the answer machine, but like I said, 90% or better, you're going to get a live person to answer. The phone number to call regardless is 270-753-0053 or 1-800-844-5108. You can also reach out by email at jeff@jeffrobertslaw.com, or on my website. It's got a chat function on there that you can interact with and answer questions, and then that will be sent to me. It's not anybody here in my office that you're chatting with on that, but when you do that gets sent to me shortly after. Or if it's during business hours, sometimes they will connect you directly over to the office if we're available, and you want to be connected over at that point in time. But if not, then they send it to me, and then we will be back in touch with you just as quick as we can be if you reach out to me through the website.
Outstanding. And that website is jeffrobertslaw.com. There's always the standard contact us form right there where, again, maybe you're a third shifter, maybe nobody's going to be in the office, but you can give some information, give your phone number, and Jeff and his team can get in touch with you the following business day.
Yeah, and I have clients that do that. They use email now, but before, early on, because of their work shift, they would reach out through that chat function. I get notified by text whenever I get an email of it, but they notify me by text that they sent the email to me with the transcript of that contact from that standpoint. And if it comes in at 2:00 in the morning, I'm not calling you, and I'm not going to see it until the next morning from that standpoint. So, but we will be back in touch with you. And frankly, there's been time where it's come in at 8:00 at night, and I look at it and could tell that the person was having great anxiety over what was going on, and I have reached out to people at nighttime in that situation. Generally, I'm not going to see it till the next business day, as a general rule, because just don't look at it
24/7.
Don't. Yeah.
Well, Jeff, it's been a good conversation with you. I appreciate this. We've talked about recorded statements, both in the motor vehicle accident situation, so car wrecks and motorcycle wrecks, trucking collisions, but we've also talked about how they work, and they're a little bit different in the workers' comp environment. As always, I appreciate that, and I love the fact that you've got the two offices now to make it a lot easier for your clients, and that just, again, extends your presence out there, and it makes it a lot easier for them to get to an attorney who has 31 years of experience and has a pretty good idea what he's doing when it comes to helping them with their claim.
Still in business. So.
Still in business. Always good, brother.
Yeah.
All right, my friends. Hey, that's a wrap for this episode, and we'll be back in a couple of weeks.
Thank you.
Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.